Sam. He's a special needs education and the special needs education and advocacy project. He's a comprehensive disability special needs planner with Silver Tree Special Needs Planning upon earning his bachelor's degree in economics. He began a career in the comprehensive disability and special needs planning. He's been in the industry for 7 years, working with individuals and families with special needs and disabilities. He's also a volunteer with a nonprofit organization called Special Needs Education and Advocacy Project. Through this organization, Andre donates his time, shares his knowledge by providing complimentary educational presentations to organizations like ours, groups, and conferences who have loved ones that are a part of the special needs and disabilities community. So welcome, Andre Sam.
Afternoon, everyone. As mentioned, my name is Andre Sam. I'm a comprehensive disability and special needs planner, and through our nonprofit organization, the Special Needs Project, I speak at various conferences and organizations throughout the country about disability and special needs planning. And on the PowerPoint, you're not going to really be able to take too many pictures because it's a lot of bullet points. A lot of the information I'm going to go over, it's probably going to be advised for you to take notes. I do have some handouts, a little short at the moment, so those of you in the back who have not received it, fear not. My wife will be returning shortly with more of them, and there are a couple of notes pages on the back where you're able to take some notes or just take some notes on whatever you have planned. And a lot of the information today, it might feel like it's information overload. So, along with the information guide I handed out, there is an evaluation form for you to be able to fill out at the end. Tell me what you liked, disliked, want to see changed, and there is a place where you can check a box if you would like to have a private complimentary meeting with me to discuss these things, and I'll be happy to do so either sometime today or tomorrow, sometime this weekend, or at a later date over the phone or in person, because I do get around, so don't be surprised if I visit with you in person and you're in Maryland or New York or Chicago or wherever. So, a lot of the questions as well are not going to be able to be answered today, so that's another good reason why there is that complimentary private meeting that's offered too. But for our session today, we're going to talk about disability and special needs planning. And is this a clicker thing, whoever? Is this it? Yeah, perfect. Green button? No? Play. Ah, perfect. There we go. All right, so some of you have probably heard of disability and special needs planning but don't know what exactly is involved. So by the end of the session, you'll have a much better understanding of it and what's important to consider. And a lot of times people who are aware of it, they believe it's important, but when you actually look at the numbers, most people have not done the proper planning. So if it's so important, why is it that so few people have actually done it? Well, a couple reasons are people don't know what exactly is involved, where and who to turn to for resources, costs and fees involved with it, and as well, a lot of times you're just trying to make it through the day. You're focused on day in, day out things. You're not focused on things that might not have an immediate effect on you or your loved one. But disability and special needs planning, if you plan properly, you're going to open up a lot more doors for your loved one in the future for their continued growth and development. So here's some things to consider that we don't like thinking about quite often, but something happened to you. You were no longer around. What is going to happen? Who's going to look after your loved one? What kind of lifestyle do you want them to continue having? How much is that going to cost? Those are all important things to consider. So when it comes to comprehensive disability and special needs planning, I break it down into 4 areas. There is the legal planning, which we'll talk about first, then government benefits, budget and financial planning, and then last but certainly not least, lifestyle and transition planning. So as far as the legal planning goes, a big topic for many people is guardianship. When is it appropriate, when it's not? I just want to gauge the audience here a little bit. Just by the raise of hands, how many of you have a loved one with Duke 15 or any other physical or intellectual challenge who is under the age of 18? Okay, anyone over the age of 18? Those of you raising your hands, how many of you are the court-appointed guardian or conservator? Okay, we'll have a further conversation about that. How many of you have a loved one who's between probably 14 and 18? Okay, so it's become probably a little bit more real for you. So, for all you mama bears out there, please do not claw my face when I tell you this, but when your loved one is 18, you no longer have the legal right to make decisions for them. Okay? Before you lunge at me, let me tell you what you can still do. At 18, just like you and I, we have our own rights. We're adults. And there's nothing in the Constitution that says otherwise for an individual who may have an intellectual or physical challenge. Okay? So, in order to retain that right, you need to petition the court for guardianship over your adult incapacitated child. Okay? Each state varies. All of you are from all over, so each state, each county varies. But usually it's a process where you fill out some paperwork, file it with the court, you go before a judge, the judge grants the guardianship, and then you're able to continue making decisions for them medically or financially or one or the other, depending on your situation. Now, I'm not going to tell you guardianship is good or bad. That's not my place. But a lot of times people get incorrect information that guardianship is bad, it restricts my loved one, or guardianship is the only thing that's needed and that's the most important thing. I'm not here to tell you one way or the other, but here's kind of a way that you can start thinking about if guardianship is appropriate for your loved one. So think about your loved one. And if they were walking in the mall alone, and all of a sudden one of those cell phone booth kiosk people comes up to them and starts talking to them and says, "Hey, I got this brand new shiny iPhone 10 here. It can be yours. No money down. All you have to do is sign this piece of paper." You know your loved one better than anyone. Are they signing that paper? If they are, guardianship might be appropriate for you. If your loved one is not capable of making medical decisions for themselves, guardianship might be appropriate for you. Because if you have guardianship and your loved one did sign that piece of paper, that contract is void. It's an invalid contract. Doesn't work. Okay? And a lot of times people think that if I have guardianship over my loved one will never be able to drive. They'll never be able to get married. They'll never be able to vote. That's not necessarily true. Just like when they're a minor, can a minor get married? At a certain age, yes, they can. You as a parent just have to sign off on it. That's all. Will they be able to drive? Well, just like you and I, we have to go through the driving test, pass it, and then you as the guardian have to sign off on it. That's essentially it. Voting, if they show the ability to vote and they express that desire in the court before the judge that they want to vote, they can retain that right. Okay? But they will not be able to sign contracts alone if you have guardianship over financial decisions. Okay? So guardianship will also, like I said, be able to give you access to medical records if you go for guardianship over the person for health decisions. And a lot of times, the alternative to guardianship is power of attorney documents. Sometimes it's appropriate, sometimes it's not. One way you can figure out whether power of attorney is even applicable for you is if your loved one is capable of understanding the document. If they cannot understand the document, can't do power of attorney. Okay, that's the first hoop you gotta jump through. Because they're the ones signing off on the power of attorney, and they can change that or terminate that power of attorney at any point. So most of you are probably not from around here. It's kind of a little family vacation for you. If you had some sort of family emergency and you went into the hospital and you want some certain procedure done or some sort of shot or immunization for your loved one, but they're over 18, you don't have guardianship, it's possible that the hospital would say no because they don't want to be on the hook from a liability standpoint. But if you have guardianship, that will go through. Guardianship works across state lines. Power of attorney is flimsy at best. Most of the time, it will not work over state lines, and sometimes even in your own state, it won't. A lot of times people are pushing to not have guardianship, that, like I said, it's restricting your loved one's rights, and that's not the intent. The intent is to provide them with a safety net so they can continue growing and developing. Okay? And unfortunately, a lot of agencies and institutions don't really talk to each other, and they won't accept anything but guardianship. Another tip, if you're going through the guardianship process and you want to pay an attorney, you can do that, but oftentimes you do not need an attorney. Sometimes it's good to have one, but oftentimes you don't need one. If you don't see anyone fighting you for guardianship, you could do it yourself and save yourself a couple $1,000, because sometimes it can get a little pricey just depending on where you live. So if you're willing to put in the time and fill out that paperwork, then you can do it yourself. But that's a common misconception people have with it. So that's a little bit about guardianship. Like I said, sometimes it's applicable, sometimes it's not for each person's situation, whether now or in the future. More than happy to have a further conversation about that with you. Now, the next important part to have in place is the legal documents. And the first one is what's called a last will and testament. And just by the raise of hands, how many of you have a will in place? Okay, I'm actually impressed. That's more than half. All right, so this is the first important document to have in place. And basically, this is a document that states you exist. You have stuff, and you're expressing who you want to have these things. The important part in a will is that this is a document where you list who is serving as your successor guardians. I know in the documents that our firm creates, we also list out anyone who you do not want serving as a successor guardian. Because in each of our family trees, sometimes you'll have a bad apple here or there, and you just simply don't want that person overseeing your loved one. So while it's important to list your successors, it's also important to list out who you want excluded. Now, having a will is better than having nothing, because you do have some control. But if you only have a will, your assets will go through probate. And just by the raise of hands, has anyone dealt with probate before, gone through it, or know someone? It can be a pain in the butt. It can be very timely and costly. A lot of times it'll take between 6 and 24 months to get things resolved, and the government will come in and take 5 to 20% of your assets for doing their job. That's the way they view it. Okay? So that's one big part that we need to solve. The other big part is that if you leave anything directly to your loved one, if they right now or in the future are going to have SSI or Medicaid services, if they receive those assets, that will get them kicked off, and those assets could potentially go to Medicaid for payback from services that you've received up to that point. So those are two issues that we need to solve for. So the way that we do it with the first part is this revocable living or family trust. And just by the raise of hands, how many of you have a revocable living or family trust? Okay, the numbers are starting to dwindle a little bit more. All right, so the purpose of having a revocable living or family trust is that you have more control over your assets. And the biggest part is that your assets will avoid probate. So, whoever you want to have those assets in your family trust, you'd list them as the beneficiaries and whatever conditions that you want them to receive them under. In a family trust, you could put contingencies in there, such as if they are, if they're using drugs, if they are mentally unstable or so, then that restricts them from receiving their assets, or upon completion of a bachelor's degree or reaching a certain age, they get those assets. So whatever you want to do, you can put in there. But the biggest part, like I said, is that with a family trust, those assets will avoid probate. So you have your will, and then in your will, you simply list that the beneficiaries of your assets are the beneficiaries of your family trust. The executor of my will is the trustee of my family trust. Okay? And in the family trust as well, it's probably important to list out not only who is to serve as successor trustees or who's to receive those assets, but also anyone that needs to be excluded from either managing those assets or receiving those assets. So that solves that first problem of the probate issue. But it still doesn't solve the second part, because if you list your loved one by name in the family trust, then that will get them kicked off of SSI and Medicaid, and those assets could be going back to Medicaid for payback. Okay? So the way we solve that last part is by having a special needs trust. And just by the raise of hands, how many of you have a special needs trust? How many of you have heard of special needs trusts? Okay, a little bit more. All right, so we'll go through different types of special needs trusts and get some things clarified here of what types might be applicable for you, what might not. But with the special needs trust, the gist of it is that you can leave assets for your loved one's benefit that will not get them kicked off of SSI or Medicaid and not be subjected to lawsuits and creditors. Okay? That's the gist of it. There are different types of special needs trusts, and sadly, the most common one that I see, which is completely legal, let me preface that, it's completely legal, but it is not as beneficial as others, is called a testamentary special needs trust. And this is basically when you have a family trust or a revocable living trust with special needs trust wording inside of it. If this is what you have, it's better than nothing, but a lot of times it does not have all the necessary disability and special needs law in place to protect those assets from SSI and Medicaid payback or disqualification. Okay? And I can go into that in more detail in private or if we have time at the end. The best type of special needs trust to have in place is what's called a third-party, separate, irrevocable special needs trust. Third-party, separate, irrevocable special needs trust. Going forward, I'm only going to refer to it as third-party special needs trust. I'm not doing that whole thing. With a third-party special trust, you, grandma, grandpa, anyone can leave whatever amount of assets to it for your loved one's benefit, and it will not affect their benefits. And upon your loved one's passing, those assets will go to the beneficiaries you want those assets to go to. They will not go to the government for payback. Okay? Anyone can put money into a third-party special needs trust except for one person. That's your loved one themselves. They're the only person that can't put any of their own assets into it. Okay? That's where the third-party term comes from. It's third-party money. So if you have these lined up correctly, you'll have three documents. You have your last will and testament, which continues to refer to your revocable family trust. And inside of your revocable family trust, that's where you would list the special needs trust for your loved one. And a lot of times it's their first and last name, special needs trust. So it could be, I'm leaving, 50% of my assets to my, maybe typical child, Jane Doe, and I'm leaving 50% to the John Doe Special Needs Trust. So even though it has their name in it, it's not them. It's the John Doe Special Needs Trust. It's its own entity. If it's drafted properly, it comes with its own tax ID. So the minute that you sign those documents, it's active. It's in place. You could turn around, go down to the bank, open up a checking account in the name of that special needs trust and put assets into it. That's usually the best route to go. Okay? If your loved one does have assets in their name, they would have a first-party special needs trust created. A lot of times this is used when someone has an accident later on in life and they have assets and they reach some sort of legal settlement. They receive a large lump sum from that and they need Medicaid assistance or so. Those assets are placed into a first-party special needs trust in order for them to qualify for those benefits. The difference between the two is that the first party does have SSI and Medicaid payback, where the third party does not. Okay? I know I just threw a lot of legal jargon at you, and probably half of it went over your head. That's totally fine. I totally understand that. Like I said, I'm happy to speak with you afterward in private. But if you have those things in place from a legal planning standpoint, that takes care of that. Power of attorney, let me just get to that real quickly. I said that's one of the alternatives to guardianship. Power of attorney documents are something that each and every one of us should have as well. This isn't just for your loved one if it's applicable. So, for example, my wife has my medical and my financial power of attorney. So she's able to act on my behalf if I went outside and got hit by a bus. Okay? Those are important things to have in place so that people can carry on making those decisions for you based upon what your wishes are. Okay? So that's the legal planning. The second part is the government benefits. And with the government benefits, there are 3 types of cash benefits and 2 health benefits. The cash benefits are Supplemental Security Income, or SSI, Social Security Disability, or SSDI, and Social Security Retirement Survivor Benefits. So let's talk about SSI first. Oftentimes, if you have a disability or a challenge prior to the age of 22, you'll be able to qualify for SSI. However, if your loved one is under the age of 18, Social Security will look at both the parent's income and assets and the child's income and assets. Oftentimes, because of the parent's income and assets, the person won't qualify. Okay? So, does anyone here have a loved one who's under the age of 18 and is receiving SSI? Yeah. It's far and few between on that part. But once your loved one reaches the age of 18, it's based only on their own record. It's based only on your loved one's income and assets. Usually at 18, most people don't have income or assets. So that's where they'll qualify. Okay? The maximum amount currently that the federal government pays out for that is about $771 a month. And the government feels like your loved one can live off of $771 a month. I'm not here to say yes or no to that. I'm just relaying the information to you. Okay? However, on the flip side, if your loved one reaches the age of 80, that's over $1 million in cash benefits. Okay, I believe 100 years ago, life expectancy for Down syndrome was about, I think it was 15 years or so. And then about 50 years ago, it was 30, and now it's about 65, 70. So life expectancies are increasing on that. So that's one thing to consider there. Okay? A lot of states, if you qualify for even $1 of SSI, you'll automatically be enrolled in Medicaid. If your loved one's under the age of 18, doesn't qualify for SSI, there's still a chance that they could get Medicaid. Just by the raise of hands, does anyone here have Medicaid-related services or Katie Beckett Medicaid? Okay, how many of you have heard of Katie Beckett Medicaid? Okay, a couple there. So for those of you who don't qualify for SSI, you can still apply for the Katie Beckett Medicaid waiver in your state. And this gives you the ability to access benefits for occupational therapy, speech therapy, voc rehab, like I said, speech therapy, occupational behavior therapy, those types of programs, even if you're not receiving SSI. Okay? So I'd strongly encourage you to look into that. If your loved one is under 16, 17, because oftentimes states will have wait lists, and you could be waiting a couple of years to be able to get access to these programs. But you'd be able to keep them on your health insurance while getting these Medicaid waiver services. It sounds like some of you have already benefited from that. And oftentimes with SSI, there is some confusion between that and Social Security Disability. Social Security Disability is something that anyone who has paid into Social Security for at least 10 years would qualify for. So for myself or for many of you, if you got hurt and you're permanently disabled and you've paid into Social Security, you're probably eligible for Social Security Disability. But if you haven't worked, you're not going to get Social Security Disability, you're going to get SSI. So in most of your circumstances, it would be SSI for your loved one. Okay? The nice thing about it is if your loved one is receiving SSI, and upon either your retirement or you passing away, your loved one will get a bump in the amount they receive each month. So they usually collect about 50% of the benefit. So if you had a $3,000 Social Security retirement benefit, well, half of that's $1,500. $1,500 is more than $771 a month. So they get bumped up to start receiving $1,500 a month. So that's a nice part about it as well. When your loved one does eventually go from SSI to Social Security, retirement, or survivor benefits, they will undergo a 2-year transition from Medicaid to Medicare. And there's often confusion around Medicaid and Medicare, so let me get those clarified for you. Medicaid is your state health insurance program. Medicaid is your state health insurance program. And that has the asset and income limitations the same way SSI does. Medicare is the federal health insurance program that you receive either when you're retired or when you're receiving some sort of survivor or retirement Social Security benefits. Okay? And the reason why, like I was saying, even if you're receiving $1 of SSI, most states automatically enroll you in Medicaid, and you don't have to deal with that process, is that we encourage your loved one to continue growing and developing to the maximum extent possible. If they're working and they're bringing in a paycheck, their SSI will go down a little bit. That's okay. Want them to get out there in the workforce if they're capable of doing so. But even if they're getting $1 of SSI, they're still on Medicaid. And Medicaid provides group home funding. So if you're looking for any sort of group home funding assistance or so, that's not through Medicare. That's through Medicaid. So a lot of times we think that when we get old and need some sort of nursing home or assisted living facility, a lot of people say, I got Medicare, I'm covered. No, you're not. No, you're not. Medicaid covers group home funding. And again, in order to qualify, you need to have less than $2,000 of assets, and you have to make, depending on your household size, but for an individual, it's about $1,200 a month, just give or take which state you're in. Okay? I don't know if any of you have gone through the experience with parents or other family members who need to spend down their assets to qualify for some health insurance programs or so. That's Medicaid, and they're having to spend down their assets. We don't want that to happen. We want you to hold on to those assets so they're able to supplement your loved one's lifestyle that you desire for them while receiving this type of assistance. Okay? Let's see. And I know it's a little blurry here. This might be one worth taking a picture, or it will be available online, wherever that may be. But about the differences between Medicaid and Medicare and where they come into play and have the same things in common. So some things, Medicaid, federal and state assistance program, varies by state, benefits people with low income and resources, provides long-term support. Medicaid waiver programs, participants pay little or no part of the coverage. Participants receive regular dental and vision exams. Medicare is your federal program, same program nationwide, benefits people who have reached 65 or have become disabled right around 62 or so. Like I said, it does not provide the long-term support. Participants pay part of the deductibles and costs of coverage, and it's divided into 4 parts, but there are additional coverages. And where they have things in common is inpatient hospital care, outpatient hospital care, prescription drug coverage. Medicaid eligibility. Most states automatically grant Medicaid when you get approved for SSI based on disability. Most states let the Social Security Administration handle Medicaid enrollment for SSI recipients when they are approved for SSI. Individuals in those states will receive information about their Medicaid enrollment along with their SSI award letter when they are approved for SSI. Oh yeah, one more thing, I'm gonna go back to SSI. When you apply, and you apply online, it's important to not submit that until they are actually 18. If you submit it prior to 18, it will be considered as a minor, which means they'll take your income and assets into consideration. That could get them denied right away. And don't be surprised if regardless of your circumstances and how good or bad they may be, Social Security will oftentimes simply deny you. So just be okay getting denied the first time around if that's the case. Social Security has this little strategy where, hey, if we deny most people first time around, well, a lot of people will quit and give up, and we won't have to pay out. So you have to go through that appeal process. You can appeal it. It's usually about a 60-day window that you have to do it, but usually second, third, or fourth time around, yes, it's frustrating. You can get approved for it, okay? So don't get discouraged if you get rejected the first time around. Let's see. This talks a little bit about the states that Medicaid's administered by Social Security and other states that are administered directly by the state. Some states have their own Medicaid rules that are different from SSI, slight differences in income as far as eligibility goes. Again, this will be online. Let's see. 10 states where Medicaid has, like I said, more restrictive requirements than SSI. Connecticut, Hawaii, Illinois, Minnesota, Missouri, New Hampshire, North Dakota, Ohio, Oklahoma, and Virginia are those states. Let's see. So that's all for the government benefits at this time. One other thing with it, though, a lot of times people get concerned that their loved one is on their health insurance plan, and they get worried that, well, my loved one's turning 26 soon, and they're not going to be able to stay on it. I would check with my health insurance coverage if I were you, if you like the services that you receive through your health insurance company, and maybe Medicaid doesn't pick up the tab for those, and you want to keep them on it. A lot of times, your loved one will be allowed to stay on your health insurance plan for the remainder of their life, as long as you're still working at that place or you pass away while you're at that place. If you want them to stay on it, you'd obviously have to pay the premiums, but if you want them to stay on it, I would definitely look into it, because over the past 5-6 years or so, there have been new laws that have been created where an individual with a disability or special need is allowed to stay on their parents' health insurance plan after the age of 26. Okay, so keep that part in mind as well. Now, as far as the budget and financial planning aspect, this part, it's a little hard to tackle. You know, finances is a taboo subject, first off, so no one really likes talking about it. And a lot of times we don't really sit down and actually look at how much it's going to cost for our loved one to sustain the lifestyle we want for them. So we need to look at how much things cost now and potentially how much things are going to be in the future. With certain people out, that could be an absence of services. Those services, well, if you want them to sustain them, how much is it going to cost? Those are the things to consider, but we also have our own individual goals as well. Retirement, or educational goals for other kids, or anything else that we have. So we have to balance both for our loved one as well as for ourselves how we're going to do this financially. So we need to look at assets, liabilities, income, and expenses. It's important to do the proper beneficiary changes and retitling your assets. A lot of times people will get the legal planning done, which is fantastic. Great, good for you. But then they don't actually retitle any of their assets into their trust. That's the second part, and it's just as important, if not more important, than the first part. Because if you don't put those assets in, it's not going to be part of the trust. So you need to change things like your house deed, or change your bank account, investment accounts into the trust so that they avoid probate. Okay? And then beneficiary changes on retirement plans, life insurance policies, things of that nature. It's one of the most common things that I see is people have done all the proper planning, they have all their legal documents in place, they've done all the financial planning, but then grandma passes away, and unbeknownst to anyone, she actually had a $25,000 life insurance policy, and she took it out just for your loved one, and your loved one's that beneficiary. That $25,000 goes to your loved one, gets them kicked off of SSI and Medicaid, and, well, even though you haven't been paying for those Medicaid services, don't think for a second that the government has forgotten what they provided you. Don't think that for a second, because they sure haven't. In some computer, in some government building, you have a tab of all the services they provided. So if you have a $20,000 bill, well, that $25,000, it's now down to $5,000, and that's still more than the $2,000 amount. So they still don't have Medicaid anymore. They still don't have SSI, and that money that was supposed to go from grandma to your loved one is now just going to the government. So it's important to make sure you have the proper beneficiary changes so that it is going to the Special Needs Trust instead. Okay? And then depending on everyone's circumstances, some people may need a little bit more help from outside sources. There are trust companies, there are custodians, and other third-party organizations that can help out in managing the finances for your loved one if or when you're no longer around. And then there are also ABLE accounts, and I'll talk about that here for a second. How many of you have heard of ABLE accounts? A couple people. All right. So ABLE accounts are still pretty new. They've been around for about 5 years. Basically, they're like a checking or savings account for your loved one that also protects their eligibility for SSI and Medicaid. It's not something you can just simply go into your local Wells Fargo or Bank of America or wherever and open up. ABLE accounts are operated by each and every state, and this is the main website you can go to, www.ablenrc.org. You can pick your own state to open one up in. You can pick a different state. There's a features and benefits option. You can compare states. Some states offer tax incentives for any money that's been contributed to an ABLE account, while others do not. So you just have to see which one is appropriate for you. But if your loved one's getting $500 checks from grandma for happy birthday, and probably many of you have had this circumstance where you can't make the check out to them, you can't give it to them, give it to me, you have to hide that money underneath a pillow, something like that. Well, you don't have to do that anymore. Because with an ABLE account, if that check is made out directly to your loved one, you can take that check, put it into their ABLE account, and if it goes over that $2,000 mark, that's okay, no big deal. It's not going to affect their eligibility. The maximum amount that you can put into an ABLE account each year is $15,000, which is a tremendous, wonderful problem to have if you're facing that. But just keep in mind, if you go over that $15,000 in contributions, then it's no longer protected from SSI and Medicaid. It's treated like any other account that's in their name. So that can get them kicked off of those benefits. And sometimes people think, why can't I just do an ABLE account? Why do I need to do a special needs trust? Seems so much simpler. Well, because on your assets, you can't leave your assets to an ABLE account. That would be like someone stating in their documents that they're leaving, X amount of assets to your, Charles Schwab account. No, it's to you. It's not just to the Schwab account, it's yours. So you can't just simply leave it to an ABLE account. That's why the special needs trust is still important. It's your long-term vehicle for holding assets for your loved one's benefit while protecting their eligibility. Okay? But if your loved one is working, they could do direct deposit of money into the ABLE account as well. So that's a nice benefit too. If it goes over that $2,000 mark, no big deal. Like I said, they'll continue receiving their benefits. A lot of times people think, okay, I have to limit my loved one's hours at work. They can't make X amount, or they're just saving that money away. And what do I do? Well, if it goes over 2,000, it's not a big deal. Okay? It's usually only about a 30-minute setup process online. Like I said, if you go to that website, it has an interactive map of the U.S., and you can pick and choose which state you want. It'll take you directly to the state ABLE website for whatever state that may be. And there's a comparison chart on there. Let's see. And last but not least is the lifestyle and transition planning part. So, what was it? It was a couple years ago. I had an individual by the name of John that came into my office, and he came in with his sister and brother-in-law, and John had oxygen deprivation at birth. He was nonverbal, used a wheelchair, and we're sitting there, and I'm talking with his sister and brother-in-law, and all of a sudden, John's in his wheelchair, and he starts bobbing his head up and down, going, "Bubba, Bubba." So we stopped conversation. And I said, "What's John saying?" She's like, "Oh, he's saying bubbles." And my response was, "Oh, blowing bubbles?" And she said, "No, the bubbles in his carbonated beverage. It tickles his throat as he's drinking it." It's a cute little, subtle story. But the point is, if I was to be living with John, or if you lived with John, would you know what Bubba meant? No. So even though we've put these legal plans in place, we have these government benefits, we've even done the budget and financial planning, I'm going to just about guarantee that for most of you, to your loved one, none of those things matter. What matters to them is having their peanut butter and jelly sandwich on white bread with the crust cut off at 1:05 p.m. every day. They care that someone understands them. So, what we do so that any future caregivers know and understand your loved one is we create what's called a letter of intent. This is basically a guideline into who your loved one is as a person. What are their likes, dislikes? What are your goals for them? Behaviors. Do they behave differently behind closed doors as opposed to around other people? All those things are important to document so that someone, whoever it may be, that's coming in and looking after your loved one can hit the ground running and understand them and make them feel as comfortable as possible, because with you not around, it's already going to be difficult enough for them. Having someone that can see, know, and understand them is going to be very crucial. We can create a letter of intent a couple of ways. It could be a couple of these things combined too. One way you can do it is you can just have a written document. Write all these things out. However, sometimes you can't really do it justice by writing things out. I'm sure each and every one of you knows something about your loved one that you just can't write it. You have to see it yourself. So, other things you can do: pull out your phone, video record them in different circumstances. If it's related to the bathroom, of course, dress them appropriately, make them the star of their own show for those purposes. And then take those video recordings, put them on a USB drive, and attach it with your documents. Or a lot of times what we'll do with people is we will create a private YouTube channel. So no one can just simply go on, put the title, and you actually have to have the username and password of the account to view these different videos. So that someone's going in, they're able to see for themselves certain tendencies, behaviors, or whatever it may be. You can also do audio recordings. So just simply talking about any and everything about your loved one is going to be able to help that future caregiver, which is going to help your loved one as well. So if you have the legal planning in place, government benefits, the budget financial planning, and the lifestyle and transition planning, that's a comprehensive special needs plan. Okay? If you have those things in place, you're taken care of. You're putting your loved one in the best position possible. Okay? I know we're running short of time here, so I want to thank you all for coming. I do have an evaluation form, like I mentioned. If you're able to either put them on the back table or just leave them at your table, tell me what you like, dislike, want to see changed. If you would like to meet privately with me, either sometime this weekend or at a later date and time, happy to do so. Just check that box. Happy to provide that for you. And how are we doing on time here? Yeah, we're on? Yeah, okay, perfect. So yeah, thank you all for attending and hope this was helpful for you.